Chapter 8. Employment of School Teachers. 1. Parties to the contract. The employment of public school teachers is very generally regulated by statute, and it will be found that in all the states the authority to employ teachers is conferred upon officers variously styled as directors, trustees, or committees. It is through these agencies that the school district or school township acts, and when the officer acts within the scope of his authority he binds the district. School districts are quasi-corporations, and are capable of suing and being sued, and on breach of a contract legally made with the district or town, through its proper officer, a right of action accrues as against such district or town. A contract made by such school officer with a person to teach in a public school in the district for a period extending beyond the trustee's term of office is valid and binding on his successors in office. Any person possessing the proper certificate of qualification required by law, and who does not labor under some legal disability, is competent to enter into a contract to teach. An infant possessing the requisite qualifications may, with the assent of his parent or guardian, contract to teach school. Where a minor with his parents' consent contracts for himself, or where he is compelled to go abroad and do for himself, the minor is entitled to receive his earnings, and payment to him is a full satisfaction. It has been held, however, that emancipation of a minor does not enlarge his capacity to contract, but merely entitles the minor to his earnings. It is well enough to bear in mind that, as a general rule, an infant who makes a definite contract to perform services may put an end to it whenever he chooses. In such a case the infant may recover proportional compensation for the services performed, subject to any reasonable offsets. Although no suit can be maintained against a minor for breach of contract of service, yet damages sustained by reason of such breach of the contract may be set off against the minor's claim for services. At common law married women are disabled from making such contracts, but in many of the states legislation for the removal of this disability has been adopted, where one member of a board of directors or trustees contracts with the other member or members. Such a contract has sometimes been held void on the grounds of public policy. Sometimes the school office has been held to be vacated thereby. The duties of teacher and trustee are incompatible. 2. A certificate prerequisite. Before any contract to teach can be entered into, and as a prerequisite thereto, the teacher must have and produce a certificate of mental and moral qualifications, signed by the proper examining officer. Circumstances cannot supersede the necessity of this certificate, nor can the committee waive it so as to bind the district. In Tennessee the common school commissioners are indictable for employing a teacher who has no examiner's certificate. In Vermont, however, it is held that the requirement of the law is satisfied if the certificate is obtained on the evening of the first day of school. So, if it appears that a certificate was made out at the proper time, by the proper officer, upon satisfactory evidence of qualifications, this will suffice. Although by accident or neglect the certificate was not put into the teacher's hands. In Vermont, it is said, the certificate need not contain any statement of the good moral character of the teacher, although a good moral character is essential, and must be inquired into by the examiner. The certificate of a majority of the superintending committee of a town, produced by the schoolmaster to the agent employing him, is a valid certificate under Main Reverend Stat. Ch. 17, although that majority did not act together in the examination. If the teacher has obtained a certificate without fraud, or use of improper arts on his part, although the certificate was issued without any examination having been made, still, it is said, this complies with the law to such an extent that the lack of examination is no defense to an action for the teacher's salary. Any contract made with a teacher who does not possess the required certificate of qualifications is void, and the teacher can draw no pay under it. And this is so, even though the superintending school committee, whose duty it is to make the examinations, neglects or wantonly refuses to examine the teacher. A school district has no right to waive this requirement of the law, and consent to judgment. Any person interested as a taxpayer in the district may enjoin such judgment. The county superintendent is not entitled to an injunction to restrain a person from teaching a public school, or the officers from paying for such services out of the school funds of the district, on the ground that such teacher is acting without a certificate of qualifications in violation of the laws of the state. Such a proceeding may be maintained by any citizen or resident of the district, but not by the county superintendent, merely by virtue of his office, under a statute which declares that the certificate which the school commissioner is required to grant to teachers after examination shall not be valid for more than a year without the approval of such certificate by the commissioner endorsed thereon, and which requires every teacher to obtain and produce such certificate before employment. The spirit of the law was complied with, although the commissioner did not approve the certificate in writing, but declared the teacher competent, and gave his sanction to the previous arrangement of the school in the presence of the trustees. A teacher's certificate of qualifications obtained from the school commissioner is prima facie evidence of his being qualified to perform the duties of a teacher, and it devolves upon the school directors to prove incompetency or neglect of duty when they have dismissed him for either of these causes. The contract is, in many of the states, required by law to be reduced to writing. Where this is the case, questions arise as to the ratification of a parole contract, and its effect. In Kansas it is said that one teaching in a school without a written contract is entitled to receive the reasonable value of the services performed. In Iowa, where a teacher had made a parole contract with the directors of a school district to teach 9 months, and had taught 7, receiving pay therefor, after which he was discharged, it was held that although the contract did not comply with the statute requiring such engagements to be in writing, nevertheless the acceptance of part performance was a ratification, rendering the district liable on the contract. Where the law requires the contract to be in writing, and there is a written contract between the teacher and the district, it will be conclusively presumed, in the absence of fraud, accident, or mistake, that it contains the entire agreement of the parties as to the subject matter covered by it. 4. Conditions of the contract. The contract of the teacher is to teach his pupils what he has undertaken, and to have a special care of their morals. The contract is for the personal services of the teacher, and such teacher cannot substitute a proxy, however competent. If a teacher leaves his place and fails to resume it, and when requested to return insists that it is sufficient that he has left a competent substitute, this is cause enough for dismissal. The law does not require the highest order of talents or qualifications in a teacher. It only requires average qualifications and ability, and the usual application to the discharge of his duties to fulfill his contract. The contract is necessarily subject to any conditions imposed by the law from which the power to contract is derived. Thus, where a statute empowers the board of directors to employ teachers and remove them at pleasure, the statute enters as part of any contract made under it, and the teacher employed by contract under it may be discharged, notwithstanding the terms of his employment. It sometimes becomes a question whether the statute under which the contract is made gives the right to dismiss a teacher at pleasure. It does not, unless clearly so expressed in the statute. Thus Wagn. Mo. Stat. 1243, seconds 7, making it the duty of the directors to manage and control its local interests and affairs, and giving them power to hire legally qualified teachers, gives them no authority to dismiss a teacher unless for good and sufficient cause shown. In case of their wantonly obstructing him in the discharge of his duties, or dispossessing him of the schoolhouse, they would be individually liable in damages for tort. A clause in a contract between a school district board and a teacher, reserving the right to discharge the teacher whenever he fails to give satisfaction, is valid, under a statute which provides that the county superintendent may dismiss for incompetency, cruelty, or immorality. Where the contract between a teacher and the school district contained a stipulation that she would leave if the school was not satisfactory, it was held that dissatisfaction with her school, and not personal unpopularity in the district, would be a reason for dismissal under this provision. When a teacher has been irregularly dismissed, his subsequent continuance in the school, with the assent of a majority of the trustees, is a waiver of such dismissal, and a satisfaction of the original employment. Unless such power is conferred by statute, the trustees of a school district have no right to dismiss a teacher holding the proper certificate, without cause, and against his consent, before the expiration of his contract. Where the teacher of a public school contracted to faithfully and impartially govern and instruct the children. to strictly conform to the rules established by the Board of Directors. To perform all the duties required of her by Part 8, Sections 41, of the school laws, and it was provided in the contract that if she should be dismissed by the subdirector for a violation of any of the stipulations therein, that she would not be entitled to compensation after such dismissal. It was held that the subdirector had a right to dismiss her for a failure to control the school, even if she was not unfaithful in the discharge of her duties. Where the word month in school contracts is not defined by statute, careful officers and teachers avoid any question by making their contracts for a certain number of weeks. The word month has various meanings, there being calendar months, solar months, and several kinds of lunar months. In law the word month means either a calendar or lunar month. The civil or calendar months are the months as adjusted in the common or Gregorian calendar, and known as January, February, etc. A lunar month, the period of one synodical revolution of the moon, is, in mean length, 29 days, 12 hours, 44 minutes, and 2.87 seconds. But in popular usage 4 weeks are called a lunar month. Under the Old English common law the word month, whenever it occurred, was construed to mean a lunar month of 4 weeks, except in mercantile contracts, in which it was construed to mean a calendar month. In some of the states it is provided by statute that the word month used in contracts, instruments, and statutes shall be taken to mean calendar months. The tendency of the courts of this country is to give the word the meaning of calendar month, and in contracts such as that of a teacher it is generally so held, unless there is some statute to the contrary. In New York it is provided by Reverend Stat, Volume 2, Chap. 19, Tit. 1, Seconds. 4, p. 799, that where the word 6 month occurs in any statute, act, deed, written or verbal contract, or private instrument whatever, it shall be held to mean a calendar month, unless otherwise expressed. The school month is defined by statute in many of the states. In Mississippi and Wisconsin, a school month is 20 days. In Maine, in the absence of an agreement to the contrary, a school month is 4 weeks of 5½ days each. In Arizona, Arkansas, California, Iowa, Kansas, Louisiana, Michigan, Minnesota, Missouri, Nevada, New Jersey, and Ohio, the school month consists of 4 weeks, of 5 days each. In Kentucky, Illinois, and Pennsylvania, the school month is 22 days. No deduction from the teacher's wages can lawfully be made on account of holidays, such as Christmas, January 1st, July 4th, and the fasts and thanksgivings appointed by the President of the United States and the Governor of the state. A contract to teach school does not imply that the teacher is to sweep out, make fires, or do any janitorial work, nor would the fact that his predecessor had done such work without extra compensation make any difference. It must be part of the contract, or the teacher cannot be required to do such work. 5. Breach of the contract. If the contract is broken in any manner by the teacher, he of course forfeits his right to any further compensation, and renders himself liable to dismissal. If a teacher in a public school, although he has been employed for a definite time, proves to be incompetent and unable to teach the branches of instruction he has been employed to teach, either from a lack of learning or from an utter want of capacity to impart his learning to others, or if in any other respect he fails to perform the obligations resting upon him as a teacher, whether arising from the express terms of his contract or by necessary implication, he has broken the agreement on his part, and the trustees are clearly authorized to dismiss him. As has been stated, in treating of the conditions of the contract, the law does not insist upon the highest talents, but it does require the teacher to bring to his work at least average abilities, and the usual industry and application to the discharge of his duties. If he fails in this respect his contract is broken. The school district on its part contracts to pay, at the times fixed in the contract, such sums as the teacher will be entitled to as salary. A failure on the part of the district to make such payment gives the teacher a right of action. The teacher is peculiarly entitled to be paid for his important and arduous services by those who employ him. If a teacher is employed for a definite time, and during the period of his employment the district officers close the schools on account of the prevalence of smallpox in the city, and keep them closed for several months on that account, and the teacher continue ready to perform his contract, he is entitled to full wages during such period. The act of God is not an excuse for non-observance of a contract unless it renders performance impossible. If it merely makes it difficult and inexpedient, it is not sufficient. Although under such circumstances it is eminently prudent to dismiss school, yet this affords no reason why the misfortune of the district should be visited upon the teacher. 6. Remedies. The remedy of the board for failure of the teacher is dismissal. The teacher has one of two remedies: action on the contract, or a writ of mandamus. Mandamus, and not an action for money had and received, is the proper remedy to compel a clerk of the school district to pay over money in his hands applicable to a warrant issued in favor of a teacher for salary. The funds are the funds of the district until he parts with the custody of them. A teacher is entitled to a writ of mandamus to compel the trustees to pay arrears of salary due him. He has his option to bring suit to recover the money, or proceedings for a writ of mandamus to compel its payment. And if an order has been issued to him, and it remains unpaid, he may still have his choice of remedies. The creditor of a corporation is not restricted to mandamus as his sole remedy. Where the school law allows the local directors to employ a teacher, the latter may sue the Township Board of Education for breach of the contract. When the school trustees take away a teacher's pupils from her schoolroom, although she had a contract with them and was ready and willing to teach the school, they are nevertheless not individually liable to her. But where the teacher is wrongfully dismissed on charge of incompetency or any similar charge, he is entitled to recover from the district his wages for the balance of the term contracted for. Where the teacher has performed services without any contract, or without a proper contract, he is nevertheless entitled to recover the reasonable value of his services. It has been held that the declaration in an action by the teacher for salary must contain an averment that a certificate of qualification was exhibited to the directors prior to the commencement of school. Mandamus will lie to compel the officers of a school district to reinstate a teacher whom they have removed without authority. 1%. Defenses. The fact that the teacher did not possess nor exhibit the certificate of qualification required by law will, in most of the states, defeat any recovery by the teacher. This requirement is always enforced with great strictness, because it is the best safeguard the public has against the impositions of incompetent teachers. It is true that incompetent teachers may be dismissed, but always at the expense of confusion and delay, and the school interests are too important to be thus trifled with. In an action by a teacher to recover for his services, proof of his employment by the agent, and that he rendered the services, makes a prima facie case, and if the town would avail itself of the want of a certificate it must show the fact, as it will be presumed that the agent did his duty. Although a teacher of a public school may not be entitled to recover her wages by reason of having neglected to obtain the certificate required by law, yet the town alone is entitled to make that objection, and if money has been paid by the town to the school agent, to be by him paid to the teacher, he will hold it to her use, and cannot object to the want of a certificate. But where the money placed in his hands by the town was placed there absolutely for the use of the school teacher is a question of fact for the jury. Payment of the teacher's wages by the town to the committee does not discharge the town's liability to the teacher. Incompetency, incapacity, or failure to perform any of the obligations resting upon him as a teacher, will authorize the dismissal of a public teacher, and defeat any recovery for salary after such dismissal. As previously stated, the production of a teacher's certificate casts the burden upon the school directors to prove incompetency or neglect of duty, when they rely upon either of these causes as grounds for dismissal. The certificate is prima facie evidence of the teacher's qualification. Incompetency of a teacher is a question of fact to be found from the evidence. Where in an action for wages it was pleaded, among other defenses, that the plaintiff was incompetent to manage the school, that she was unreasonable in her requirements of the pupils in the school, and was uneven in her treatment of them, and partial and abusive in her treatment of certain ones in her school, and that she failed in all respects as a teacher of said school, it was held that evidence of particular instances of mismanagement in her government of the school was admissible. It has been held in an action to recover salary that evidence that a majority of the voters in the district were dissatisfied with the plaintiff, and that the plaintiff and the prudential committee who employed plaintiff knew this at the time the plaintiff was employed, is inadmissible. Where an order on the treasurer was left at a teacher's boarding house in full for her services, which order she took, but returned in 2 or 3 hours, saying that she did not accept it, it was held that she lost none of her rights thereby. The fact that a teacher who had been dismissed carried off the school register, but returned it to the school district clerk before bringing suit for wages, will not defeat a recovery for wages. A teacher cannot lawfully be paid for his services until he has made a report to the superintending committee, when required by law. It is no defense to a teacher's suit to recover salary that the certificate was given to the teacher without any actual examination, when the certificate was obtained by him without fraud or the use of improper arts on his part.